estate, we want to recognize Molly Schnook. Molly is not here. But anyhow, Molly did a terrific job with us in establishing these brown bags, and we did that back in 2015. I also today want to recognize, if there's anybody in the room who's a sponsor. I said Pat Ramsey signed up, and somebody from Third Federal. Was anybody, any of our sponsors?
We all give you money.
We all give money. We have to have special counters put in there to handle it all. But I do appreciate it very much, and without the sponsorship and without the support of those people who are providing the leadership for ideas for these things would never happen. And without further ado, Ben Fowler was the one who came up with this. He was on the conference planning committee. This is an old issue, and I just, these things never go away. Lack of banking and lack of credit in inner city neighborhoods, guess what? You have these kind of predatory products. Last April, we had John Powell as our speaker, a well-known urban politician, urban researcher. He was the Kirwan Institute, and now he's out in California. And his first slide in his presentation, I don't know if many guys were there, this is April when we were over in law school, was a slide of the home that he grew up in, Detroit. Green home, 3 bedrooms, 2 bathrooms, family of 5. Dad was an industrial worker. Same thing, predatory loan. He kept it for 20 years. Bought the home for $10,000. He sold it for $5,000. I mean, this is a story of America. I mean, all the fair housing issues about how did African Americans get into white neighborhoods, it was with these predatory loans. And so, swing back, and here we are all over again, thanks to your great research about thousands of people in Ohio with these loans. It tells you the same thing that was going on in the 50s and the 40s in American cities, that African Americans can't get access to credit. It's a market that is just broken. And so these fine panelists are going to tell us how we're going to fix it and resolve the problem and make credit available. But thank you all for coming. We appreciate you, and know that our next conference topic is going to be on county housing policy and big bucks coming to housing. Right? Ben, turn it over to you.
Well, Chip, thank you. Can everybody hear me all right?
Yes.
Okay. So, hello, welcome. Thank you for coming out today to be a part of this conversation. My name is Ben Fowler. I teach community development law at Case Western Reserve University School of Law, so an extra thanks to Cleveland State for letting me on the campus. I am honored today to be joined by a panel that I will call esteemed, composed of Victoria Jackson, a state policy fellow with Policy Matters Ohio, Sarah Buduson, an investigative reporter with Cleveland's News 5, and Stephen McGarrity, executive director of Community Legal Aid Services. You should have bios for each of the panelists in your materials, and so I'm not going to go through the process of reading and repeating that, but I'll encourage you to take a look because we really have some folks up here with some extraordinary qualifications. But I do want to call some special attention to some of the work that each of them has done that brings them to the table today. In particular, Victoria's July 2018 report for Policy Matters Ohio titled Predatory Land Contracts Strip Wealth from Communities studied the prevalence of land contracts across Ohio, described the many ways in which they harm individuals and communities, and offered a series of suggestions for legislative reform. Sarah followed up in November of 2018 with a well-researched and thorough investigative report that I think we're going to have a chance to watch in a moment, titled Designed to Fail, The Rise of Rent-to-Own Leases, where she explored the impact of land contracts and rent-to-own schemes and told the real in-home stories of several homeowners who were really taken advantage of under this model. Finally, Stephen's organization, Community Legal Aid, has filed a lawsuit on behalf of several Youngstown residents against Vision Property Management, alleging a range of predatory and exploitative practices in its rent-to-own business model. As a side note, and a way to link this back through to some of the work the other folks have done, Vision is one of 2 particular companies, the other being Harbor Portfolio Services, that was sued for its business practices by the city of Cincinnati in 2017. And so these 2 companies have really attracted a lot of the attention for their widespread model. That being said, they're not the only players in the area. Before we get to hear from our panelists, I'd like to start us off by framing the issue a little bit and distinguishing between a few different types of arrangements that we see in practice. The term land contract is often used somewhat interchangeably with rent to own or lease purchase or even lease with an option to purchase. And while there's some common elements to each of these, there are also some fundamental differences in how they operate and how current law governs them. And that also defines some of the options that we might have available to address them from a policy and a legal perspective. So land contracts and rent-to-own arrangements both exist in the same space between a conventional lease and a conventional purpose. They're not fully in one world, and they're not fully in the other. So I'm going to bring a chart up on the screen real quick for you.
And it was passed out.
It was passed out.
It was passed out.
Good.
I just got one.
There we go. So here's another copy up here. You can probably see the copy in front of you far better than me. So I'd like to focus your attention on the middle two columns of this. On the left, we've got a conventional residential lease. On the far right, we've got a conventional residential purchase. And the framework that I want to highlight for you is that a lease purchase, whether the landlord follows the law or not, is something that is governed under Ohio landlord-tenant law. And that imposes certain restrictions on the lessor, the landlord, the seller in this case, and provides certain rights for the tenants. The key thing in here, as a distinction between land contracts and lease purchase, is that those protections for tenants don't exist under a land contract. It comes from a separate part of Ohio law. It is not a landlord-tenant relationship. And the landlord, or the seller in this case, does not have those obligations to keep the property habitable and safe and to maintain it. They assign that typically to the vendee, the purchaser in this case. And so using the law as it is designed are able to shift almost all the responsibility over to the buyer. Whereas in a lease purchase, as long as it's under a lease, whether the landlord honors it or not, they have those responsibilities under Ohio law. All right. So the other point that I'd like to put out, and I think it's something that's been covered in some of the panelists' work as well, is that not all land contracts and rent-to-own arrangements are bad. There are plenty of examples out there of land contracts and rent-to-own arrangements being used legitimately and for important purposes by community development organizations, by affordable housing organizations, as a way to help people access home ownership when they're not able to use traditional conventional mortgages and credit vehicles. But there are elements of these things that make them susceptible to abuse. And the common theme is that they allow the seller to shift almost all the responsibility and risk to the buyer, while the seller retains control and the ability to relatively quickly and easily take back possession in the event that the buyer isn't able to make the payment or gets overwhelmed or finds themselves in a house that needs far more repairs and far more work than they had been led to believe. The result, in too many cases then, is the deal falls apart. The would-be buyer loses everything. The seller is able to walk away with the property, any improvements that were made, any money that's been paid to date, and start all over again. As Chip noted, these are not new things. We've seen them over decades and decades, and yet they keep coming back. We've seen a resurgence in the last decade in particular in the wake of the foreclosure crisis. We even know that the numbers are larger than what records suggest. One of the challenges is that while land contracts are required by law to be recorded, there's really no penalty or enforcement mechanism for when that doesn't happen. And we see example after example of land contracts in place, whether it be from a code enforcement perspective, whether it be if something ends up in a dispute in an eviction case or foreclosure action, we find out then that there was a land contract that was never recorded. So we know there are more of them out there than the numbers suggest, but even so, the numbers, as Victoria's helped us to understand, are pretty significant to begin with. So it's a big issue, but it's even bigger than public records give us insight into at this point. The other thing that I'd like to contextualize at this point is that the reason why these things have come back, there are several reasons very much related to the focus of this conference series and to the work that the Fair Lending Coalition has done over the past number of years. Two of those elements are that we have a surplus of post-foreclosure, investor-owned properties, often in poor condition. So we've got a market flood in this one respect. On the other hand, we've got mainstream lending practices that don't fully meet community credit needs, which means we've got a lot of people out in the community who would like to be home buyers, who are able to be home buyers, but can't access conventional lending vehicles. And then finally, we have some consumer protection rules that have evolved more slowly than the people who are looking for ways to get around them. So at the intersection of these issues, we end up with land contracts and rent-to-own schemes as a way in which investors are able to cheaply acquire properties in questionable condition and get a solid income stream from them in the near term without actually having to meet the requirements and burdens of being a conventional seller or of being a conventional landlord. It's a way to separate that responsibility, whether legitimately or not. The result, as our panelists have told us and will tell you today, is disastrous for both the individuals involved and the communities in which they live. So with that in mind, we'll move on to hear from our panelists. We'll take a few minutes from each of them. We'll open it up for a few moments of questions after each presenter. And then my hope is that at the end, after we've heard from everyone, we'll have some additional time where we can engage in even further discussion. So thanks for bearing with me. Victoria.
Good afternoon. I'm Victoria Jackson. I'm a researcher with Policy Matters Ohio. As you know, we're a nonprofit, nonpartisan research institute. And we came to this issue, we were brought to us by our partners in the Mahoning Valley. So Youngstown Neighborhood Development Corporation and Trumbull Neighborhood Partnership. They came to us with stories from residents that were like, they bought a house, they were making monthly payments, they put a down payment on, they're making repairs, they've been paying off a tax lien, and then they find out the person who actually owned the home is being foreclosed on. Now they're being kicked out of the home and they've lost all the money they put into the home. And so when they came to us, we understood that we needed to sort of document the issue in the state and understand where things were going. And so we sort of looked into it, and as all of the things that Ben already mentioned, that about seller financing, etc. And so when I heard that story about like seller financing and contracts, it made me think of things that I heard about in the past about Black people buying houses on land contracts. We're in this meeting, and I'm thinking, made me think of the case reparations by Ta-Nehisi Coates, and it made me think of Richard Rothstein. And I was like, maybe this is not so new, even though we're hearing about it now. And so land contracts have a racist history. That's just simply the case. And it's connected to legal racial housing segregation and redlining, which I'm sure many of you are aware of, a grading system by color. Green is the best desirable, red is undesirable. And that were neighborhoods that were predominantly Black, predominantly people of other racial ethnic minorities and immigrant communities. And so through the process of redlining from the 1930s to the 1960s, the federal government barred Black people from receiving federally backed home loans and home mortgage financing. And so because Black people were shut out of this, they really didn't have many options for home buying. And so they were often only left with the option of land contract buying. And so when you have this option and all the sort of issues that Ben mentioned, you have these sort of unscrupulous and racist speculators come in and take advantage of Black home buyers. And they put them in predatory land contracts with inflated home prices and with impossible to fulfill contract terms. And as Ben mentioned, so those contract terms, if you miss a payment or you don't make a repair on time, you can then be kicked out without any recourse, no foreclosure process, and no protections. And so basically, these were basically designed to siphon wealth from black families and enrich sellers. And so you have the situation where black families lost their homes, all the money they put into them, and then it has this long-term effect. It's one of the contributing factors to the massive racial wealth gap that we have in this country. And so when we see this resurgence, what we're seeing is it's happening again. We're having it in communities that are locked out of traditional credit, usually because they're low income, because of race, because of credit history, and they're being targeted and preyed upon by predatory land contracts, by these investment companies that are national companies that are not from Ohio coming in and preying on communities. And so when we did this report, I know Sarah's going to talk more about the challenges of getting data, but what we found is from January 2008 to January 2018, there were over 47,000 recorded land contracts. And of course, that does not reflect the actual number of land contracts, but we did all 88 counties, we used online systems, or we called, and I put as much usable data as possible. Like Montgomery County, I had to kick out because their system did multiples and there was no way to differentiate, so I kicked them out. They were an outlier, so they're not in there. They're the only one that's not in there. So we did that report, and the county with the highest number was Trumbull County. They had over 2,700 recorded land contracts, and then the top 10. Trumbull, Stark, Franklin, Lucas, Summit, Mahoning, Cuyahoga, Clark, Butler, and Lorraine. So that's where, but as that's not surprising. These are some of the largest, more urban counties, so there's more people. In the report, I also have land contracts per capita. I didn't do per mortgages because that would have been another 88 county data. So I just did by per capita. And what you see with that is that it's more concentrated in the southeastern part of the state in Appalachia. So you see some of these distressed areas there. So one of the things we did was do some recommendations for legislation. And when we had come to this work, Representative LaFleur-Hagan in the Mahoning Valley was already working with Washington, D.C. and TNP, and she had introduced legislation in 2017, House Bill 368, to get some consumer protections for Ohioans. And so we did our own recommendations, apart from that report, apart from some of the, we considered best practice recommendations from the National Consumer Law Center. And we, basic things, make sure the house is habitable and up to code before a contract is entered into. Require sellers to pay for independent inspections and appraisals. Sellers to pay off all liens on the property before they enter into a contract. For contracts to clearly state the obligations of sellers and the rights of buyers. And then also that deviations from the contract should be permitted only when a buyer and seller both have an attorney, which I know sometimes people have different feelings about that one. And then that buyers have the right to sue sellers for contract violations and can be awarded money damages. And then bar forfeiture clauses. They were on that original slide, but that's basically if a person is in a land contract and they haven't been paying for more than 5 years, or they haven't paid more than 20% of the home price, they can then be kicked out of the house through eviction, and they don't go through a foreclosure process. And that the state should be, and then also bar prepayment penalties, any unfair, deceptive, and abusive practices, and that the state should be monitoring and enforcing compliance and also collecting data on these contracts. So currently where we are with legislation, as I mentioned, House Bill 368 was introduced in 2017. It didn't really go anywhere. So then there was a push in our lame duck session to have an amendment to get through, and that didn't happen. And so there were certain discrepancies between House Bill 368 had more consumer protections. It was a stronger bill. The amendment was a little more lax. So right now, it's promising there is bipartisan support for this bill. Representative LaFleur-Hagan has got Representative Manning. He is a Republican to support a bill in the House, and then Senator Ruley, who is a Republican, and Senator O'Brien, who is a Democrat. They're all from the Mahoning Valley, are supporting the Senate bill. And so currently right now, things are sort of up in the air. What will that final bill that is introduced look like? Will it have stronger consumer protections, or will it be a little more lax? People think that's something that could get passed. At Policy Matters, we support a bill with the strongest consumer protections to protect Ohioans from predatory land contracts, and that is what we hope is introduced, and that is what we hope is ultimately passed. But as you know, things. So, yeah, exactly. So that's sort of my overview.
All right. Well, I guess I'll open it up briefly. Does anybody have any questions for Victoria based on that at this point? Councilman?
go back over those numbers of how many registered land contracts? 2,000?
Yeah, there's 2,706 in Trumbull County, and that's the highest. And then total, there's 47,610 recorded in the state. Yeah.
And all the state and all the municipalities have the state requirement of required to.
Yes, that's state law. So that contracts have to be recorded by the seller within 30 to 20 or 30 days. But it's just, they don't record them, and then, you know, different cities have different ways of, it can be difficult to get that information.
So with your data research, what do you think the true number is?
I wouldn't even begin to be able to even estimate that, because if what I did, my collection wouldn't sort of talk about people who didn't, I'm unaware of people who didn't file them.
Andy?
How many in Cuyahoga County?
There were 1,592 recorded from January 2008 to January 2018.
I see a hand back there.
Again, Bill Althouse, legal aid. Question about the recording. Could you talk about that a bit? There isn't any penalty, but what's the purpose behind the recording of the land contract? And how does that relate to pre-existing liens on the property that might tip off of ND that they could be subject to a mortgage and potentially a foreclosure?
Yeah, no, I think that's a really good point Phil raises. I mean, with respect to any sort of real estate arrangement, the purpose of recording generally is to put the world on notice. In this particular situation, one of the concerns that I think we've identified in our conversations and the research that we've done is that without that recorded instrument in public record, these things are invisible. It just appears on county land records as the title still being in the name of the seller, because with a land contract, the transfer of the title doesn't occur until the very end, until the entire series of payments has been satisfied. Seller holds on to that title all the way through the process. So, as Phil notes, there really isn't any sort of penalty for a seller for failing to do that. And there may well be some advantages for them to keeping it out of county records. I'll tell you my experience when I first encountered these was when I was working at the Cleveland Housing Court, and we would see properties brought in on code violations, and the titled owner would come in or would send someone in and say, oh, well, actually, we're not responsible. This is a land contract. We've assigned that away. The responsibility for the code violations, for the taxes, for the property, all of that has been assigned by land contract, and here's the person who's actually responsible. And under the current law, they're right. They are allowed to assign those sort of responsibilities away under the contract. And so what we would see is someone who thought that they were a homeowner, who was actually in a land contract. It wasn't recorded. And so there was no general notice to the public at large or to anybody else, who now found themselves being prosecuted for the failure to resolve code violations on a house that was, in technical terms, a hot mess. Yes?
Does that stand if the land contract had not been recorded?
Yeah.
Yeah. So the remedy that they would have is really primarily canceling the contract. But oftentimes, by the time that comes up, the person is so invested in it, they've got so much into it that doesn't really solve their problem. And the exit often happens just by walking away.
What if there's a term to the lease? So this land contract lease purchase agreement is actually termed like a traditional rental lease is. Mm-hmm. And so you can't get out of it because it's termed. Mm-hmm. And obviously you lose all the money and everything. But where does the liability then fall? For who's responsible for those issues? So
if it's a lease, if it qualifies as a lease under Ohio law, the landlord's responsible. Exactly. And a court's going to look at different factors. They're going to look at that allocation. They're going to look at the way it's titled. the way it's styled and how well it conformed, whether it fits better as a land contract under 5313 or better as a lease under 5321.
And it's the seller's responsibility to record, right? The buyer, can the buyer do that process? Can the buyer record?
I don't know that there's anything out there stopping the buyer from doing it. But you'd have to have a more sophisticated buyer who knew that there was some advantage to that. The other thing is that that might not be their first priority, even if they know that, because it doesn't buy them something specific at that moment. It's really a larger benefit is the public record knowledge, so we can get a handle on what's going on.
But it is the responsibility of the seller.
Yep. Lisa.
Sorry. In your research, in your study, 47 is a big number. Was there any actual looking or comparing of the actual tenants? So did you find anything?
I did initially attempt to look at documents and to even try to like map by census tract, etc. But that was getting really time consuming and a bit unwieldy. And so I do have some contracts pulled and filed away, but I didn't really do much analysis of the actual contract.
All right. Well, in the interest of time, I'm going to move along and we'll to Sarah. And I would say if you still have questions, hold on to them. Maybe we'll resolve them as we move forward. But we'll have some time at the end to come back as well if there's something still on the table. Do you want to start with the video?
Yeah.
Okay.
First thing we're going to do is watch my story, Designed to Fail, so you can see what I've done on this. And it really just kind of piggybacks off of everything Victoria just said and everything Ben has discussed thus far. One thing I would say is, why did I do this story? There wasn't really enough data out there. It made me, there was a point where I said, oh my gosh, should I even do this? Because there's not really the data that I would want. I can't have one database and say I found this many contracts and this number of people got totally screwed over. I can't say that. However, I decided, because all of the experts, some of whom are in this room, and maybe like right next to me, maybe Sally, Tony in the back, Heidi, who could be, you guys should be up here. All these people who are experts were telling me it's a problem. And so I believe that the scope of the problem is significant enough to take it on. And the impact of what can happen to somebody when it goes wrong, as you're about to see, was worth taking the time to put together a story, even though the data that I really wanted to have really wasn't there. So let's check this out. And I don't know why I'm wearing the same dress today.
One dress lady.
Yeah, I mean, I planned it.
Remember, when the housing bubble burst, out-of-state investors swooped in and scooped up thousands of foreclosed homes here in Ohio. Then credit dried up. Those investors needed a new way to make money. So they turned to a form of lending that can work, but as you're about to see, it's often predatory.
The house was gorgeous. It had like a Princess Palace window and 4 windows, a tower window.
And Luana Williams' little girl loved its pastel colors.
My daughter used to walk by the house when we go to the store, go to the place. She would say, Mom, I would love to live in the house.
When a bullet took Andrea's young life, Luana bought the home on Elgin Avenue.
So to me, it was like kind of having a piece of heart. You know, that's what it was when I was able to accomplish.
But then she lost the house too.
I felt like I deceived her. Like I let her down once again. I couldn't save her life. And now I can't say the house she wanted.
Luana fell prey to a form of predatory lending.
In some ways, the exact opposite of a regular mortgage.
Ben Fowler is a law professor at Case Western Reserve University and housing expert.
You see contracts in some ways reminiscent of what we saw during the height of the mortgage boom that are designed to fail.
Land contracts and rent-to-own leases, which are similar, are advertised as affordable ways to own homes. But those who sign them often end up worse off.
They try to sell the American dream.
Take Ernest Hayward.
But in reality, they're doing nothing but selling snake oil.
He signed a rent-to-own lease for a house in Cincinnati. It was filthy, and he soon learned he was on the hook for city fines over its condition. Then he discovered something even more troubling.
I feel totally disappointed, misleaded.
A fraction of his monthly payments went to the principal.
I feel like they're gangsters with the paperwork.
So it's kind of the worst of both worlds for the buyer.
Here's why. Like a homeowner, the buyer is responsible for property taxes and repairs. But like a renter, miss even a single payment, and you can be kicked out.
Seller can just take you to eviction court and evict you like a tenant, and you lose whatever you've put into it.
That's how Luana lost her home.
They just took it. Like, okay, F it.
After falling behind on payments, she scraped together $10,000 to give to Harbor Portfolio Advisors, the company that owned her home. They evicted her anyway.
You feel like you got robbed?
I know I got robbed. I think about that $10,000 every time I'm in a bind.
She's not alone. Since 2013, we found 10 eviction notices involving only 8 homes that the Dallas-based company owns in Cleveland. Another company, Vision Property Management, based in South Carolina, filed 21 eviction cases during the same time period.
I would say they're housing predators.
For years, Ian Beniston has watched the two companies operate the same way in Youngstown.
So they can get the most amount of money out of the least value properties by doing the least amount, right?
As the head of the Youngstown Neighborhood Development Corporation,
things like this just make it even more difficult for us to,
he says their properties often end up abandoned.
Dig ourselves out of it.
Taxpayers want to pick up the pieces.
The people that own this aren't coming to clean this up. It's going to be city government.
I think it's a problem that we can't look away from.
State Representative Michelle Lepore-Hagan was so concerned, she drafted legislation to force companies peddling land contracts to fix up their homes and have them appraised before they can be sold.
We want to close the loopholes. We want to close the loopholes that people are able to manipulate.
In the meantime, the city of Cincinnati sued Harbor and Vision. Both companies settled. Wisconsin's Attorney General is also suing Vision, and so is a nonprofit legal group on behalf of Youngstown residents. We reached out to Vision.
We'd like to speak with you.
They have no comment
about your rent-to-own leases.
Harbor Portfolio, which closed its doors earlier this year, said eviction was a last resort, and they would work with consumers that had fallen on hard times.
They ought to be made to put fix these houses up that they're giving people, lying to people about, and let them stay there.
After she was evicted, Luana had nowhere to go. A church stepped in and housed her family for a year. Her daughter's dream house was demolished.
It was good. I loved my neighbors. It was real good until they put me out.
So far, state leaders have failed to stop the predatory practices. Lepore-Hagan's proposed law, which she introduced last year, has been stuck in committee in Ohio's heavily Republican legislature. But the Democrat remains optimistic. She says a Republican lawmaker is now on board, and they will reintroduce her bill in January. I'm 5 on Your Side investigator Sarah Buduson.
Well, as you can see, the significance of the impact when things go awry with these land contracts. That's something I wanted to talk about, and something that came up over and over again. Those are the 2 stories I featured. And I think you understood this from the story. These people did not completely understand what they were signing up for. I think many of us out there, I don't understand the details of my mortgage, right? I'm just trusting, you know, the people I've worked with are doing the right thing. But I can go through traditional means without any issue, and I could hire an attorney if I really had to. These people just did not understand what they were doing. Obviously, Luana's story is incredibly sad. What is also sad about it is, I'm not an attorney, but my producer and I were looking through her case. We think at the time this happened to her, that she had a reasonable case to be able to stay in the house based on how much she had paid. She might have paid that 20% and was technically a homeowner as opposed to belonging in eviction court. But that is not something she fully understood. She certainly didn't have the means to pay. So she ended up homeless instead. The other example, Anthony, he's the kind of guy we want. He wants to come in and fix up these homes and make neighborhoods better. He's got the skills to do that and the will to take on what was really essentially a shack. But it was the code violations he didn't know he was responsible for that made him just walk away. He didn't, again, completely understand what he was signing up for, but he is exactly the kind of person we want in these kind of homes because he is improving neighborhoods. But instead, because of this, what happened is that he lost his investment and that terrible looking shack is still a terrible looking shack. The third thing I want to hit on with Harbor Portfolio that I found so fascinating is they're now out of business. So this can be a benevolent model. As I said in my intro, these folks swooped in after the foreclosure crisis. This could have been a great way to help people out when credit was so tight. Instead, what it really is a new form of predatory lending. There are some investors out there who have made a killing on this investment. They made the money and they've closed their doors. They don't exist. They say they're willing to work with people. Well, there's no entity anymore. There's no office. There's no even real person to talk to. I could go to Dallas and track down the guy who was technically running it, but the investors he was running it on behalf of, we don't really know who they are. So the bottom line is Cleveland and all of Ohio are hurting because this company, but the people who invested in this are doing great. So the people who needed the help are not getting it. And the final point I kind of wanted to make is that why Ohio? I kept asking people, why Ohio? Why Ohio? What's Ohio doing wrong? Who has a better law? Are we like, I always like to ask that. Like, if 48 states are doing something we're not doing, I should point that out in my reporting, right? That's a good solution. Like, and it's a good way to get lawmakers' attentions. Like, everybody's doing this but you. That wasn't the case here. We are just fertile territory for these kind of predators. But it's not necessarily, though consumer protections could be improved, it's not necessarily that we're failing in that regard. It's that we have an attractive situation for these types of investors. We have tons of low-income property that they can scoop up. Nobody, there are other places, Wisconsin, where Vision is also being sued, is also an attractive area. But, this isn't going to happen. I used to live in Phoenix. This didn't happen in Phoenix. Housing's nicer, newer, better. People can afford to spend some money. Here, we have tons and tons of low-income property that they can just come in and get and then make their money off of and leave without any consequence. That's about it. Any questions?
So, when Harbor went out of business, what happened to all of their contracts?
They sold them to another company. Okay. They've been sold off.
I could see the hope in your eyes, that maybe people were going to be able to hold on. No, they figured out a way to get a buck.
No, I was just wondering whether they send it to individual, investors, or but if they transferred it to another company that is just continuing to track those properties.
Mm-hmm. So, just tracking what happened to her property was challenging.
So the other big difference between purchasing a house in Ohio law, you have to get a disclosure statement from the seller about any problems, and there's a title search. So in terms of the legislation or remedies, I mean, things that could be done is, because this really is a purchase, because why have anybody looked at the whole requirement for requiring that there has to be a title search so you know about the liens, and you would require the same type of property disclosure form that would have to be provided?
So, two good points. They are required to do the residential real property disclosure under state law. That is, if you look at that particular section of Ohio statute, it defines the type of transactions broadly enough, and it actually explicitly includes land installment contracts in that. Is it happening? No, not reliably. As far as the title search, the issue is that ordinarily that would be one of the things that your lender would do. There are a lot of things in a conventional mortgage transaction that are not done for the home buyer's benefit, but that end up effectively filling some of those gaps. So the appraisal, right? That's not so you know that there's a fair value on the house. That's so the bank knows that it has a good security interest. Same thing with title. They're not doing that to make sure that you get clear title. They're doing that to make sure that they have a good security interest. And some of those external factors, because you're dealing with a seller finance transaction, there's no third party trying to protect their own interests in the arrangement in that same sort of way. Phil?
Yeah, couple things. These aren't real. We were actually talking. These aren't really sales. They're agreements to sell. Can't they? So that's kind of a loophole. In community, the legislation that's in committee right now flops or comes out of the other end and doesn't have all of the items on the wish list. And for example, let's say that there isn't any provision in the bill that requires that the vendor ensure that the property is code compliant. Can't communities, the individual communities, capture that particular issue in their ordinances? That a lot of communities actually have required that the lessors, for example, have their properties inspected and have to get a certificate and so on. There are a number of communities, municipalities in Iowa County that require that. So could that happen?
Sure. No, I don't, and I know, I'm aware of some municipalities that are even considering either interpreting their rental registration ordinances more broadly or exploring ways in which to make those apply in these sort of circumstances. I can also think of things like Cleveland's certificate of disclosure requirement on sales, where there's a certification required from building and housing prior to a transfer to identify potential code violations, historic restrictions, and things like that, put the buyer on notice. The challenge with any of that is the piecemeal nature of it, and also the fact that if you go far enough, the Ohio legislature has a history of stepping in and occupying that space. Probably our most problematic example, one of many, was Cleveland's effort back early in the foreclosure crisis to introduce restrictions to prevent that, and the state stepped right in and
said no,
occupied that space, and Cleveland lost out on its opportunity to be able to enforce that. Yes?
A big problem with the housing situation in Ohio in general is that a lot of people just don't earn enough money to pay enough money for a house to be maintained in Ohio, because the houses are old and they haven't been repaired or haven't been maintained over decades. So we can try to keep people from getting involved in these contracts, but the fact is they don't have a lot of other options. So I think we're just kicking the can around instead of dealing with a real problem, which is low wages and a lack of affordable housing. But that's a problem.
Certainly, that's part of it.
Oh, that's a significant problem. As you saw in the video, these are not homes you want to live in. I think my mother-in-law saw this. She's like, people actually live there? Yeah, they do. Her mind was kind of blown. You're right. There aren't a lot of low-income options or, low rent options or ways to get into homes. I think Tony would be the best. Tony probably knows every property in the city at this point, right? Maybe, at least in his ward. And the condition as these homes age is not improving. They're deteriorating rapidly. Winter alone takes years off a house, right? I don't know what the solution is to that. That's a tough one, yeah. But just look at the video. The conditions of the housing stock are really disturbing.
I thought what you were saying, and maybe I misinterpreted it, is we need to put a lot more energy into helping people develop skills so that they can earn higher wages. We don't emphasize that at all. We do a lot for fair housing, but we haven't put a lot of energy into helping people move up.
How to deal with that problem is obviously multiple. I just think that's really the problem. If you have enough money, you can maintain an old house. That's still. And that doesn't mean we have enough money to do it. If you look at my house, you'd say, geez, why doesn't she do this or that? Well, I did a lot you can't see. Old houses are expensive, and our landlord's not going to improve a house where the person who's renting it makes $600 every 2 weeks as a nurse a day.
If you're poor, it's because you don't have skills that somebody's willing to pay you a lot of money for. And there are a lot of jobs going vacant in Cuyahoga County that are unfilled because people don't have the skills. So I feel like there needs to be a shift to a certain extent, helping people go to certificates of Cuyahoga County Community College and other places where they can get the skills.
I am a higher ed researcher, but the skills gap is kind of a myth. Like, there's all this research that came out last week or a couple weeks ago that really the skills gap is not something that's actually a problem. We just need better job quality, and that jobs in Ohio pay very low, and that actually over in the future we look at projections for jobs. Most of the jobs in Ohio are not going to require higher education, and 6 out of 10 jobs sectors, the top 10 sectors in the state, 6 out of 10 don't pay enough to eliminate the need for food assistance for a family of 3, which is 130% of poverty, or about $26,000 for a family of 3. So it's really a job quality issue, not just a skills gap issue.
All right. Well, with that, we could spend the time we have remaining and then many, many more hours on the exploration of some of these larger issues. But I think at this point we'll move on to Stephen to tell us what's happening with community legal aid in Youngstown.
Great. So I get the next hour and 5 minutes.
Absolutely.
So community legal aid got into this issue mostly through the influence of Ian Beniston from YADC, which you saw in the video. If you ever meet him in person, he's a force to be reckoned with. He will not leave the room without taking on some responsibility for some problem he's identified in our community. So he really spotlighted the issue in Youngstown, and I'll speak for my organization, Community Legal Aid, which covers the 8 counties just sort of south of the 5 counties covered by the Legal Aid Society of Cleveland. One of the problems of legal aid is there's not enough resources, right, to pay for all the legal issues that low-income people have for representation. And so we end up sort of in this tunnel vision. So our focus in housing has been primarily in traditional landlord-tenant public housing work. And so when these issues like this pop up in the community, it sort of smells like home ownership a little bit, and so we tend not to get as involved. But what's been clear to us in the last couple of years while we were working on this matter is how really important it is for us to take the blinders off and take a broader perspective. So the other thing I'll add before I jump into what we've done in Youngstown is the big distinction between, as Ben said, land contracts and the rent-to-own, lease-to-own. To me, that difference is really getting lost in the conversation, especially at the legislative level. House Bill 368 it had a lot of good points and really addressed a lot of the issues that the Victorious report had, but it really has no effect on the lease-to-own situation when you read it. And when in the stories like Susan has, and when we talk to our clients, the most egregious abuses are happening on the rent-to-own and lease-to-own side. So with that, so what have we done? So we're lawyers. What's in our toolbox is litigation, right? It is a really blunt instrument. It can take a particular client's issue and bring it before the court to get a resolution. Our hope in taking this on was that we'll scare off Vision Property Management and others in the community who are thinking about doing this to other people, because we've done all the legwork now so that if anyone else steps up into this space in the Youngstown area or the Mahoning Valley, we have a pretty good complaint. We just dusted off and changed the names and some of the facts, but the rest of it will probably be the same. So what have we done? We're representing 4 plaintiffs in the city of Youngstown who all fell prey to these rent-to-own stunts by Vision Properties. And we filed in state court against Vision Properties, against, I don't know, like 20 or so of their subsidiary organizations, their little LLCs that they set up to hide what they're doing. The CEO and I want this job, the Chief Strategy Officer of Vision Property Management. So we've named them personally in the lawsuit, which has had some fun effect because I think they've reacted more with more concern because we're going after them individually. So we debated back and forth about what the causes of action were going to be. You know, obviously, our position is that this falls clearly under 5321, the Ohio Landlord-Tenant Statute. And so, you know, we have a number of complaints, a number of causes of action about the violations of the Ohio Landlord-Tenant and the shifting of the responsibilities of the landlord. They used for their lease something called a triple net lease bondable lease, which is really a commercial lease that shifts almost the entire responsibility of the property, including if the house burns down, they have to rebuild it. I mean, you'd take a real artisan to rebuild some of these into that conditions, but they shift all of the responsibility, and it's just a straight out violation of 5321. So, you know, that wasn't enough. I mean, you know, we really, if you try to bring an action under 5321, your damages are not going to be all that great. So we looked more closely at what they've done. We're alleging fraud, which has some greater implications for damages. We did decide to bring federal RICO cause of action as well. You know, in the report, the one person said they're like gangsters. Well, that's exactly right. They're a gangster. They're gangster. That's why we did RICO, which was the anti-gangster
that was going to
statute.
make the story.
Yeah.
Gangsters with paperwork. Yeah, that's going to be the story.
And what the problem with bringing the federal RICO claim was that gave Vision Property, and I might be getting a little legalese here, but it gave them the right to remove the case to federal court in Youngstown, which we weren't overly worried about happening if it did. But at the state of the cases right now, they've filed their notice of removal. We filed a motion to remand it back to state court. We've engaged in some confidential negotiations. We don't have a settlement. I'm not overly optimistic we will anytime soon, but what they failed to do is procedurally they made some mistakes in their motion, because we had included the city of Youngstown as a defendant in the case because they had an interest in what happened, and when they removed it to federal court, they didn't get the city of Youngstown's permission, which is a technicality, but it's a really strong technicality that we think will get it bumped back to state court if that's where we want it. So we haven't even gotten to discovery. But what I can tell you as a legal aid organization, as a director, damn, is this expensive. The amount of staff time that went into connecting with the clients, connecting with the right clients, developing their story in a way that made sense, researching the 19 or so causes of action that we have and putting it together, the complaint. I mean, it takes a lot of time and energy, and we're not even at discovery yet. It's not a really great tool if you're looking to have a big impact. It's nice for us because we get a little splash. I will say your report, we were the non-profit legal group in Youngstown that filed the lawsuit. And so that's happening. And we, after we filed the lawsuit, we've gotten lots of additional people from Youngstown and the Warren, Trumbull County area reaching out to us because they want us to sue for them too. And you know, it's potential that we might do that, but you know, on the flip side is we still have all these other clients with domestic violence and with normal evictions and bankruptcy, all this other stuff we do, and so we could spend all our time doing this, but so it's a real struggle for us. And so what's if we could come up with a more systemic solution, and that obviously is probably legislation, and this is where, you know, for us it's a real struggle to see what's happening on the legislative side in terms of addressing the real problem that we're trying to solve for these people. So the city of Youngstown passed an ordinance last week that mirrors very closely to HB 368. It doesn't have like the interest provisions and stuff like that, but it's a great tool. And if you read the local press or you talk to some of the local leaders who were touting this, you'd think we were solving the vision problem, but of course it has nothing to do with vision. I mean, just like the state land contract statute says this doesn't apply to option contracts, this says it doesn't apply to option contracts, which is what all of these clients that we have are facing. So my hope is that when there is state legislation that it's broad enough, if their hope is to affect these people, that they broaden the scope to have that. So one other little tidbit of anecdotal information in Trumbull County. Like, why does Trumbull County have such a high number of land contracts? I don't know the answer. Trumbull County is one of our counties, and I actually live in Trumbull County. I think part of the problem in Trumbull County is that people come up with really creative solutions to get around attempts to help low-income people, and that's what's happened in Trumbull County. Land contracts are now being used as a way to avoid the City of Warren's landlord registration fee and inspection. So they get tenants to sign land contracts that are like astronomically overpriced. The landlord's intending to treat it just like a traditional landlord-tenant. They're not like these crazy leases, and they're not predatory in that sense, but they're not real landlord-tenant leases. And then they go and file them, and then they can avoid paying the inspection fee on that property. So in Trumbull County, one particularly terrible landlord actually tried to did this with people who had Section 8 vouchers. And so when one of the Section 8 voucher holders contacted the health department because they had rats in their basement and they wanted some help, the health department said, "Oh, I can't help you. You own the property." What are you talking about? And so the client they became our client. They thought they had signed like an insurance form or something with the landlord who showed up one night. But they had 34 properties, this particular landlord, in the City of Warren where they did this. And 19 of them ended up being our clients, and we sued the landlord and got some damages. But other landlords, and so I live there, and so I know people who own property, and I know that they do this. And again, they're not doing it to be predatory, they're just doing it to avoid the fee. But that may be one explanation why Trumbull County is so outrageously high. So I think we'll stop there.
All right. Well, we'll open it up again for questions. Chris.
So the question came up earlier, how many of these aren't recorded, and just anecdotally in my experience, I've had maybe a dozen or so people come into my office in the last 5 years with these land contracts, and only twice have they been recorded. So I guess my question is if these lease purchases are governed under RC 5321 and 5301, and 5301 is a purchase that has to be recorded by law, it has to be recorded if you sell a house. What's the stumbling block? Maybe I just don't understand. Maybe somebody said it already and I don't get it. What's the stumbling block from requiring these to be recorded? Because it seems like even that requirement would end a lot of the shadier practices.
So
why can't they be required?
Two things on the lease purchase.
Yeah.
The actual title transfer doesn't happen at the beginning. It happens at the point it converts from a lease to a sale. So you wouldn't necessarily see that recordation until the title actually transfers. So that's the first thing. The other thing is that Ohio, you're not actually required by law to record the transfer of title. Historically, you'd be a fool not to, because it was a way to announce your interest to the world and protect yourself from other claims and other liens taking precedent. What we've seen over the past 10, 15 years in particular is people starting to play outside that game and not record even regular title transactions as a way to stay off of municipal code enforcement's radar.
And that's state law.
And it's a state law issue. Yes, the recording is, but you're not required by state law to record an ordinary transfer of title. It's that if the property has value and you want to protect that value, recording is a way to do that. But failure to record doesn't nullify the transfer between you and the seller.
Yeah, another interesting point about recording and not needing to record it right away. In Youngstown, in traditional land contract situations, there were some property owners who, when they were executing the land contract, also required the purchaser to execute a quitclaim deed back to them, so that when they breached the terms of the contract, instead of following through with a typical normal eviction, if it's less than 5 years and 20%, they would just go and file the quitclaim deed, which the Youngstown ordinance is now outlawed.
So should we be, what changes in the state law should we be advocating for?
That's a big question. And it's actually, I think, one of the things that I'm hoping we'll focus on over the next part of this conversation. But I think the work that's been done in Youngstown and what Victoria's laid out give us a really good framework for addressing those core issues with land contracts. But I think the other thing that we're seeing is that that's not the entirety of the issue. I'll tell you, the challenge overall is something that makes me think back to the treatment of payday lending in Ohio and in other states over the past couple of decades. And if you look at Ohio's early efforts around 2005, 2006, initially to address and ban predatory payday lending, the lenders just went and they reorganized, they styled it into something else, and they continued doing the exact same thing, just under a different form. And I think that that's probably one of the larger things that we need to consider. And I think Stephen's really put a spotlight on that with respect to how the land contract issue doesn't solve what they're seeing with Vision in Youngstown. I think we've got to be thoughtful as we go about this, that we're not only addressing the problems that are here now, but also anticipating the ways in which people looking to make a buck are going to try to subvert this, as they've done anytime there's been some sort of consumer protective restriction or banning of a predatory practice in the past. It's the hydra, right? You cut off a head and another one grows back, just from a different place. So, I mean, one way I think to get out ahead of that is, in addition to focusing on the land contract issue and closing those loopholes and those avenues that the law allows now that are problematic, to also create a framework in which there isn't this improper use of lease purchases as well, and strengthens the enforcement mechanism or increases the penalties, fix statutory penalties so you don't have to fight out the issue of damages and be able to prove that. Looking at different ways to prevent the workaround. I mean, what Stephen's describing in Warren as the workaround, using a land contract as a workaround to paying a code enforcement framework on the rental inspection. People are creative. And unfortunately, it's not always to our societal benefit. And so to your question, I guess I make an observation rather than giving you a direct answer. But I think that that's something that we're going to need to focus on as we look at these different processes, is try to anticipate the way in which people are going to try to get around it, and do our best to address that, or at least to be vigilant, to recognize when it comes up and then respond in turn.
You know, Ben, I've driven to Columbus many times to lobby on behalf of urban issues and fair housing and predatory lending and all this stuff. The most positive thing I heard here today was you, Victoria, when you mentioned Southeast Ohio. And this is the world of townships. And the world of townships has a political kind of bearing on the world that we operate with in Ohio, because all the leadership of Ohio had been a township trustee. So they were responsible for paving one street and building one bridge and saying there are no problems in our community and we love not paying taxes. So hearing that the fact that a lot of this stuff is going on in Southeast Ohio, which also has lots of poverty and lots of not so great housing, that there could be a real urban-rural coalition that could drive this legislation ahead in a way in which we've always had enormous problems before, because it's the 3 C's. It's Columbus, it's Cincinnati, it's Cleveland. Oh, Toledo? Yeah, sure. Montgomery County? Dayton? Yeah, we got you. Oh, Youngstown, too. They have those. But if you have this township group, and they are getting feedback about this, and townships run all over, obviously. They run Ohio. They're the chairman of these committees. They run everything. They go from state rep to state senator. They run the show. And I just think that the research that you have done on the 41,000 or whatever it is huge. If you focus like a laser on these townships and raise up how many of these homes and people have been hurt, and it's not just somewhere in Cleveland that we're taking a picture of the home, that it's in these townships, these guys would get up and do something. I mean, it's not like when we try to reach them for years on payday lending. We don't have them here, Mr. Bromley. We don't bother with them. They don't have them here. It's not a problem. And as long as they can say that, they're out of it. But the fact that they do have it and they have such large numbers representing them, I think there's a real chance of getting some legislation. And that's what I was going to ask you, Victoria, was where's the coalition? Who's driving the bus to Columbus? What's going on? No, literally, because that's what it takes. You got to go down there all the time. This is the season for fun. Here we are. We're in Morrow County again, and we're driving to the State House. But that's what it takes. It takes a group of people to go down and make the case and make the change.
Part of our hope in doing the statewide analysis was to identify rural and Appalachian areas that were affected by this. And so, of course, the larger counties come up to the top and we just look at absolute numbers, so we decided to do the rate. And so we have two maps in the report, so you see the absolute number and then you see the rate, and then you see that southeast along the Ohio River starting to come out. It's like having redder areas. And so I know a lot of the coalition has been largely focused that we're working on has been in the Mahoning Valley, but we did want to, there was talking to other legislators throughout the state, trying to get some of those rural Appalachian legislators on this. But I think the coalition is sort of going, you were on a call we had with the coalition, so I think there's hope to grow and expand this to get some more rural buy-in from that southeast part of the state.
So who's leading the coalition? You guys, or?
Primarily Greater Ohio. They've been the ones leading it, and we have sort of been involved, and like YNDC's involved, and I know Frank Ford's involved, but so we've been sort of involved on and off trying to touch base here and there. But, so that's where things are at.
Yeah, there are some folks from across the state, I think, who are all figuring out a way to get something that gives us these solutions, these consumer protections, and that we can get through, that we can attract the attention of the various different constituencies and political positions throughout. The Cincinnati folks have also been a force in this. We had a number of people in the city of Cincinnati and with some of the legal services organizations down there who were involved in the lawsuit that the city filed and settled with Harbor and Vision down there. So it's on their radar as well. Granted, it's another urban area, but Cincinnati gets traction in a way that some of the other urban areas in the state don't. So I would agree that there's the possibility of something happening here.
No, there is. I mean, if you can identify other townships across Ohio that even have a significant number of these that are going on in their community, and go to the town, not to the township, to the state reps who were formerly township trustees, and say, this is happening in your community, bring them. And I have found with these guys that going down and testifying is like going and talking to a circle. Nothing ever happens. You take them out to the township where the person has lost their home and have a community group say, well, this is where Mary used to live. Well, Mary doesn't live here anymore. She's down in the shelter because she lost her house. And she's in your community and you represent her. That's far more effective than all, I mean, not that it's not fun to drive down to Columbus, but to say, you know, this is what's happening in your community, and they're there on Mondays and Fridays. And so when they're there on Friday, go with them, find a group, say, here we are. We want to talk to you. So
bring it to the coalition.
Bring it to the coalition. Go get them.
Feel free to show them my story.
Yeah.
And in all truthfulness, that has actually been effective in helping with legislation in the past.
Yep.
Because sometimes people just need that 4-minute summary, and they really need to understand A, what the issue is, and B, the human impact. And when they hear testimony over and over again, they don't, even if it's very compelling on something that needs to be done, they don't hear it. Sometimes, yeah, it's my story. See if it helps.
There you go. Excellent. Lisa, I saw you. Yeah.
For the broad vision, the future legislation, but municipal courts, there's so many different points during this whole process where somebody needs assistance, needs benefit from somebody looking over their shoulder and providing assistance. But I'm just kind of curious, anecdotally or otherwise, if you've heard stories when these kinds of cases come before a municipal court as an eviction, and whether courts are educated enough, with all due respect, to recognize some of these serious issues that, like when you were just talking about Milana's plight and how, you and your producer thought, hey, she should have had, maybe a leg to stand on because of all the money that was invested. I mean, it just seems like this probably plays out a lot in courts. So I'm just kind of curious if anyone on the panel can speak to that.
So I can from a distance a little bit, is I know that, and had some conversations with folks at the Cleveland Housing Court, spent some time there myself, had some conversations on this issue over the last couple of years. And I mean, and you covered this in your research, is there are not a lot of cases where the issue comes up. And I can imagine a couple of different reasons for that. One is that you've already got people playing outside the bounds of the law. And perhaps what we're seeing is a self-help or some other version of eviction rather than it following the court process. I think the other thing is that in reality, most evictions end up as defaults. The tenant never shows up. And if the issue of a land contract never gets raised, then the court may never see those elements that would give rise to look further. It may well just be dealt with on a default. One of my larger points of curiosity is I know that with the work that Legal Aid in Cleveland has been doing around the idea of a tenant's right to counsel and expanding access to legal services to tenants at points of eviction, I'm curious to see whether that brings more of this to the surface. If we're connecting more people at that critical point with a lawyer who's able to take a look at these documents, we may see things that I can't think of at this point. But I think it'll be interesting what that tells us.
I want to chime in. I think, correct me if I'm wrong, because I haven't been here forever in a day, but Joe Paganakis, who himself is also practically a housing expert, it's true, said, the Cleveland Tenants Organization that used to exist is now no longer in existence, and what a loss that is. Huge. And how many calls we get to us, people who we used to refer to them, and now we do tell them to go to legal aid, but a lot of times kind of, we're at a loss. It's, we are not lawyers. We can only refer people, so that is a significant loss, and that kind of mechanism in some form or another, that kind of function needs to exist for people who are poor and to have a place where they know this is where I can go to get sound legal advice that I can afford.
Well, one point to add to that, I think you're probably going to say the same thing, is that legal aid has taken over the tenant information function that the Cleveland Tenants Organization used to do, and so it's a referral to legal aid at this point in Cleveland isn't just into the normal pipeline. It's also an opportunity to access that expansion of services that came in that transition. So it's certainly, I agree, it's a loss, but it's not an absolute loss.
Right. Legal aid is amazing. I think, like you spoke to, the need is greater than the resources, and that's what you find across the board with any issue that you delve into. I think so. It'd be really a matter of then expanding the resources available.
And the tenant information line is getting dozens of calls every day. It's flooded up. So.
It's the same phone number, and as a matter of course, legally we're just wrapping up thank you, Ben, for all of your hard work. But we're, the Cleveland Tenants Organization, we're officially wrapping up and will cease to exist officially as an organization within the next month.
But just a point of information on that, I mean, CTO was getting about 10,000 phone calls a year. That's when you think about the tenant populations and being able to have somebody on a phone line at least explore. I know, calls came through, call for action and other places, but, and they were never actually able to maintain that whole volume. So there's still a, legal aid has stepped in, there's still a need for, additional resources in that way, the tenant protection, legal protection program, things like that. But there is really a need to think about that. We have a lot of people who are calling and wanting information and help, and we're not necessarily yet in that total.
Just to point to the need, which we all know is there, the 10,000 struck me because we just did a day-long hotline to call in with housing issues. We got 10,000 calls that day.
Wow.
Wow.
Yeah.
Oof. Well, we have our work cut out for us.
Yeah. Now, are all of those legitimate? I'm sure that they're not. Just based on my own tip line, it's like I don't care about your cable problem. Sorry. Like that stinks. But I'm gonna have to. I'm not gonna be allowed to.
That's the advantage of being in broadcast.
Yeah. I'm just like I gotta go. But obviously, there's a significant need for help if you're getting 10,000 calls in a day.
Councilman, I think I saw your hand in the back.
So, just to point out, Sarah's, I visited for part of the time there to call in. It was amazing how many calls came from outside of it. There were municipalities all over the county. When you talked about the requirement to be recorded, if you recall, your court had worked with the city in instituting for businesses that are required to register for the state of Ohio to do business in Ohio. The city of Cleveland actually took a step further and made a penalty if they weren't, because the state wasn't enforcing it. Is that something the city can do? People might be able to do on requiring folks to register?
The county. Well, it seems like it's a business operation. Be conducting business in the state of Ohio, so I probably look at it in the same light that that the city has in the past in terms of pursuing real estate sellers, people engaging in business. This almost just off the top of my head, this strikes me as something that might actually involve even more of a ground game, more of an actual business presence. Because
thinking if we require, thinking a financial penalty if you don't register your land contract. This way, when they do come into housing court, and the owner says, "Well, I sold the land contract," we can immediately penalize them for that.
Yeah, no, I think there's probably something to work with there, and I think there may well be something to work with under the existing requirement under Cleveland ordinance.
Okay.
Yeah. Tony, I think I saw your hand too.
So I want to thank Sarah for putting that out there on TV because it gave people some knowledge of what's going on there. To go one step further, and we're talking about the House bill and all these changes and modifications. What can we do right now to educate people about this type of contracts that are out there? Because Cleveland Housing Board, they do landlord classes, they do tenant classes, but there's nothing out there about tenant-lord home. They give lease purchase or a land contract and see how much that would involve, and just to educate people so that they might be able to either tell somebody else about it. I don't feel that we're putting enough information out there. We're taking sources from the top, but we have to start a little bit at the bottom. So if we brainstorm on anything,
Well, I mean, I think
we identify what's in the contract and what shouldn't be in the contract. Even if we had something that we'd be able to share on that order with people, that's that question.
So in Youngstown, like again, when we first started working on this project, we knew it would be some time before we got to the point where we were going to do litigation, but we wanted to do what we could to try to mitigate the problem from growing. So we work with some of our local partners, but we developed door hangers that YNDC went out and hung on doors throughout the city, that then people would call us and say they're thinking about going into a land contract, but it had some information about what to avoid. We did bus signs that drove around the city advertising that they should call us if they're thinking out, want to buy a home for cheap, call us. We should be your first call, not Vision. I don't know how, it's hard to say in that kind of advertising how effective it was, but it was an attempt to solve the problem.
I'm with Fair Housing in East Sarasota County, and we're running a bus sign on rent to own, similar thing, get educated kind of thing. That'll start in March for so I don't know. Again, just like Steve said, I don't know what kind of response we'll get, but
yeah, if anyone wants to publish or file the door hanger.
Well, and if you have a campaign that you've started, now that we've opened the door on these housing issues, News 5 has covered housing issues for quite some time, and I brought up Joe Paganakis, and I have to give him a lot of credit for that. Bring it to us if you're doing a campaign, because we'll cover it, even if it's in a small online story. We'll always do it. It's looks good, and it makes me look good to my bosses. Like, I have this new thing that they've brought just to me. But in all seriousness, we'd be, even though I'm in the investigative unit, still bring me those updates, because if I can't do it, I will get it to somebody who can.
I think the other thing worth noting too is that there are resources out there. I'll put in a plug for the housing counseling agencies that provide services and education for people who are looking to become homeowners. I'll leave the housing counselors in the room the opportunity to jump in and say more if they'd like. But that's another potential resource for understanding what home purchase looks like, what to look out for, understanding the types of transactions. We've got some great agencies and some great resources in this county and throughout the state that may be able to help on an individualized basis in those cases.
I'm one of them. Service center, like that. But yeah, a lot of times what we see is being that we do our home buyer education course, we facilitate the down payment assistance program in Cleveland Heights. A lot of clients oftentimes come in and say, I have this big stack of papers, what do they mean? That's how we're able to help them, start to get the vocabulary. We've been fortunate to not have any situations or circumstances where folks have come in regards to land contracts in our city and in our agency. I'm sure there are some, but yeah, we're a great resource. I know housing solutions, housing sources, housing services. There's 5 of us in the county who are able to provide those services. And a lot of times, if the consumer is very confused, then we get them to a counselor, and then the counselor can make connections with legal aid and other legal avenues to help them kind of navigate that, so they feel comforted, because it kind of all hits them very, very hard and very fast when there's some stuff you have to get out. Just on that information side, it might be helpful to have a conversation with First Call for Help if that hasn't happened, in terms of their triaging when they get a call in. They try to figure out what the situation is, and they may actually not be asking people about what type of, if they hear landlord tenant or I've got a problem or stuff, they're probably just sending them immediately to legal aid, but it would be an opportunity, because they got a lot of those calls, and have staff who could then be educated and maybe legal aid to have that conversation with them,
Yeah,
in terms
everybody
of
has
their assessment of the situation, and ask that question about, did you sign any paper? And make sure you bring that with you or look.
Yeah, I think to Phil's point, I think that last piece is probably the most important, because one thing I've seen consistently on these type of arrangements is that the vendee, the purchaser, the tenant has no idea what this thing is. What they signed. They thought they bought a house. And it's really only once you start to unravel that you see that it's actually something else. And it might be, it might have a title that doesn't line up with what it actually is legally either. So there are a lot of moving pieces. I think one of the things that's also come up is that, you know, when you have companies and investors who are based outside of Ohio who don't have a particular interest in involving themselves in the state other than to make a quick buck on these properties, they're using national form contracts that don't fit Ohio law. They may fit the law of some state, they may not, but they certainly don't fall under this framework. And while Ohio's not unique in allowing land contracts, that also doesn't mean it handles it the same way as every other state. And so sometimes these things have provisions and references and even whole styles of agreement that don't line up with one of the categories in Ohio. And so that adds even another level of complication to figuring it out.
So in the teaser for this event, we got a little bit about, you know, the predatory targeted based on identity of the buyers or neighborhood conditions, demographics, right? Thinking a little bit about the claims, maybe in some of the Youngstown cases, you know, are you raising civil rights claims, or, you know, maybe Victoria, you have ideas as well about, you know, the demographics of the folks who are still finding themselves in these circumstances. I think the folks in the video are probably representative of a lot of the folks who are, you know, experiencing this, you know, both socioeconomically, racially, otherwise, right?
Yeah, so we did not raise civil rights claims directly. One of our tenants only spoke Spanish, and the entire transaction was done in English, needless to say. And so we've incorporated those facts into some of the fraud allegations and deception. So, but we didn't raise specific fair housing claims.
I'm just going to mention on the research side, I'm from the Farmers Market. We are in the process of doing this broader study beyond Victoria, beyond Ohio, and looking at 6 states in the Midwest. And just to give you a sense, we don't have demographics either on the borrowers themselves, but I can tell you that we are finding so much more areas, lower income areas with less access to traditional mortgage credit. So in our analysis, we're going to be teasing that. But this is a credit that happens in Michigan. In fact, Michigan has some of the highest numbers of contractor needs, like Wayne County. And as you've all mentioned earlier, not surprisingly, it is areas that were harder hit market areas, and some of these large investors coming in, you know, those are very prevalent. Harbor, and Stonecrest is another large one, and the ones that you mentioned. And one more thing I wanted to mention about what Chip was saying is that I just wonder, like in some of the rural areas, as we found, of course, the same things. Victoria and I get numbers together. We found some of the same things in higher numbers in the rural areas. But I wonder whether the contracts are a little different there, that they're not so by these large investors, so it's kind of a slightly different market there. And that they're not so predatory.
One of the interesting things that's come up in some of these statewide planning conversations around the legislation is that there are oftentimes normal and legitimate uses of these in a lot of rural communities. That it is a common agricultural way to transfer land. Where you don't have as much of a lending institution practice, it's not as skewed and as predatory as you're seeing it used in other places. But that's one of the things we've tried to be really conscious of in looking for that statewide agreement is making sure that we don't break something that is working while we add in the protections to limit or eliminate abuse.
And I think it's very hard to determine that because some of the loan character, it's not that the data's not right. The data we had that look at interest rates in terms of loans, it's not how you do that well. So to get it,
I just want to mention, folks, that when you came in, there was an evaluation form. It's helpful for us to get feedback from today's forum, and also we're looking ahead, and we're hoping tentatively on March 20th to do an event on Cuyahoga County's housing adventures and new development and resources that are going to be coming to housing. And if there's a topic that we haven't talked about, we've done lead and we've done different kind of things, and there's a chance to go back and redo that again, or other topics, demolition, whatever it is, be happy to do that. But if you have a particular issue that is in your community that maybe some of us haven't heard about or we missed or whatever, you're on the ground, you hear about it. You know, there's no magic phone that rises up and says, oh, do this topic. And it's like Sarah, you know, you wait for the phone to ring and see what people are talking about, their cable bill, you know, whatever. But if you have something, please tell us and mark it down on that sheet of paper and let us know. And if you came here to get CLEs, be sure to print your name and give us your lawyer number so that we can get you your credits. This was certified for 1.75, so 1 3/4 hours of CLEs for this particular topic.